Now, your team, you said you did not personally interview her on Saturday, but your team did for about 3.5 hours, correct?
Yes.
Okay. Do you know, in reading the review or the summary, did they ask Hillary Clinton about her comment that she had never sent or received classified information over private email?
I think so, but I can't remember specifically.
Do you know if they asked her when she said that there was nothing marked classified on my email sent or received?
Same answer. I'm not sure.
And so the same answer then when she said, I did not email any classified material to anyone on my email, there is no classified material. You don't know whether they asked her that?
I don't know whether they asked her that question. The entire interview was focused on, so what did you know? What did you see? What is this document? That kind of thing.
Do you know if they asked her whether she stands by the fact that she said she just used one device and that was for her convenience?
I don't know. I know they established from talking to her she used many devices during her 4 years, so I don't know whether they asked her specifically about that statement.
Okay, I guess
that's easy to check, though.
I guess my point is you're trying to get inside the head of Hillary Clinton in this investigation and know whether there was intent. And so we all know what she told the people. That's been well documented. She said that she did not do those things, that she did not send or receive classified emails, that she used one server and one device for her convenience. And since then, I think even in your statement you recognize that those were not correct. Is that fair?
I really don't want to get in the business of trying to parse and judge her public statements, and so I think I've tried to avoid doing that sitting here.
Why do you feel that's important?
Because what matters to me is what did she say to the FBI. That's obviously first and foremost for us.
Right.
Our
and
evaluation,
honest people don't need to lie, is that right?
Honest people don't need to lie? I hope not.
Okay. Well, in this case, for some reason, she felt the need to misrepresent what she had done with this server all throughout the investigation. And you guys, after a year, brought her in on Saturday, and in 3.5 hours came out with the conclusion that she shouldn't be prosecuted because there was no intent. Is that right?
No.
Is it fair to say that your interpretation of Hillary Clinton's handling of top secret information, classified documents, was extremely careless?
Yes.
And is it fair to say that you said that you went on to define extremely careless, that Hillary Clinton's handling of top secret information was sloppy or represents sloppiness?
Yeah, that's another way of trying to express the same concept.
There still is really no precedence in terms of punishment for this type of behavior. Are you familiar with Brian Nishimura's case?
Yes.
Okay, he's a naval reservist, for those who don't know, and he was prosecuted. What is the difference between his case and Hillary Clinton's case in terms of extremely carelessness and gross negligence? I think that there's been a review of this case, and they're very similar, and that's why people feel that there's a double standard.
And what they're reading in the media is not a complete accounting of the facts in that case.
Well, would you agree then with Representative Gowdy that there still is really no precedence for punishing someone like Hillary Clinton, and she could really go in, potentially be elected president and do this again without fear of being punished?
I don't think I'm qualified to answer that question.
All right, my time's expired. Thank you for your time.
Earlier today, you heard a long list of statements that Mrs. Clinton has made previously, both to the public and to Congress, that were not factually accurate. I think you went down the whole long list. When she met with you folks on Saturday last week, I take it she didn't say the same things at that interview?
I'm not equipped sitting here without the 302 in front of me to answer in that broad brush.
But it's your testimony.
But I have no basis. We do not have a basis for concluding she lied to the FBI.
Gotcha. Did anybody ask her on Saturday why she told you all one thing and told us another?
I don't know as I sit here. I mean, I'll figure that out.
Would that have been of interest to you in helping to establish intent?
It could have been, sure.
More importantly, I think, did anybody ask her why she set up the email system as she did in the first place?
Yes.
And the answer was convenience?
Yeah, it was already there. It was a system her husband had, and so she just jumped onto it.
Were you aware that just earlier this week her assistant actually said it was for an entirely different reason? It was to keep emails from being accessible? And that it was for a concealment purpose. So Uma Abedin was asked in her deposition why it was set up, and it was said to keep her personal emails from being accessible. Question to whom? To anybody? Were you aware of that testimony?
Generally, yes.
Okay. Over the course of the entire system, what she did, she intentionally set up a system According to your testimony, your findings, she was careless regarding its technical security. I think you said that even a basic free account, a Gmail account, had better security than she had. And she did that according to her own staffer's sworn deposition for the purpose of preventing access to those emails. As a result of this, she exposed top secret information to potential hack by foreign actors. You've seen the emails, we have not. I think you said earlier that the emails could be of the sort that would put national security at risk, and I think we had testimony earlier that got you to acknowledge that it might even put our agents overseas at risk.
Yeah, I don't think I agree with that, but it's still important.
Okay, all right. She kept all of that secret until after she left the State Department. She lied about it, or at least made untrue statements about it, after it finally came to light. She thereafter ordered the destruction of evidence that was destroyed so thoroughly that you folks could not do an adequate recovery. Yet she receives no criminal penalty. So I guess this is my question to you. Are we to assume, as we sit here today, that if the next president of the United States does the exact same thing on the day he or she is sworn into office, sets up a private email service for the purpose of concealing information from the public or from anybody, that as a result of that potentially exposes national security level information to our enemies, lies about it, and then destroys the evidence during an investigation, that there'll be no criminal charges, if you're the FBI director, against that person?
Yeah, that's not a question the FBI director should answer. I mean,
no, I'm asking if she does the exact same thing as president as she's done today, your result will be the exact same as it was 48 hours ago. There'll be no criminal findings, right?
If the facts were exactly the same?
Right.
And the law was exactly the same?
Right.
Yeah, the result would be the same.
And I guess under the theory that if the law is to be equally applied to everybody, that if a White House staffer does the exact same thing for the exact same purpose and exposes the exact same risks, that there'll be no criminal action against that person. That could be, as you've mentioned, administrative penalties. There are no administrative penalties, as I understand it, by the way, against the president, correct?
I don't think so, but I'm not a
I don't think there are either. I don't think you can take away the president's top security clearance, and I'm pretty sure you can't fire the president because we've tried. Not only would a staffer not have any criminal charges brought against them, but I suppose a summer intern could do the exact same thing under the theory that we're going to apply the law equally, regardless of who the people are. My question to you is this, and it's not a legal question. I guess it's a common sense, ordinary question that folks are asking me. From a national security standpoint, somebody who used to lecture on that, does that bother you?
The mishandling of classified information bothers me no matter what circumstance it occurs in, because it has national security implications.
Does it bother you that the precedent that you are setting today may well lead to a circumstance where our top secret information continues to be exposed to our potential enemies?
No, in this sense. The precedent that I'm setting today is my absolute best effort to treat people fairly without regard to who they are. If that continues to be the record of the FBI and the Justice Department, that's what it should be. The rest of the implications in your question are beyond that. They're important, but they're not for the FBI to answer. We should aspire to be apolitical, facts in the law, treat Joe the same as Sally, as Secretary so-and-so. That's my goal.
If you would come to a different decision, by the way, I tend to agree with everything you just said. If you would come to a different decision, do you think that would have a different precedential value that would keep our information more safe?
If we decided to recommend criminal charges here? I don't know. That's a good question. I don't know. I could argue it both ways. I guess I'm a lawyer. I can argue everything both ways, but I could argue that both ways.
Thank you, Director Comey.
On the issue of intent, you say it was convenience. Okay? You're a really smart lawyer. If it were convenience, Director, she wouldn't have waited 2 years to return the documents, and she wouldn't have deleted them 4 years after they were created. So you can't really believe that her intent was convenience when she never turned them over until Congress started asking for them, could you?
Yeah, my focus, and I hope I made this clear, my focus is on what was the thinking around the classified information. I mean, it's relevant why the system was set up and the thinking there, but I don't understand her to be saying, well, I think I've said it already, but that's my focus.
So I know I'm out of time, but it just strikes me you are reading a specific intent element into a gross negligence statute, not even general intent.
Gentleman's
a
time.
specific intent
Gentleman's time has
element.
expired.
Yeah. I'm sorry.
Go. The director can answer.
I enjoy talking with him. The question you got to ask is, so why is it that the Department of Justice, since 1917, has not used that gross negligence statute, but charging it once in an espionage case? And whether their decision was smart or not, that is the record of fairness. And so you have to decide, do I treat this person against that record? And if I do, is that a fair thing to do? Even if you're not worried about the constitutionality of it. And my judgment is no reasonable prosecutor would do that. That would be celebrity hunting. That would be treating this person differently than John Doe.
If teenagers in England were able to hack the personal email accounts of the director of the CIA, the director of U.S. National Intelligence, and the deputy director of FBI, does it concern you that sophisticated hackers or hackers working for foreign interests never attempted? I mean, does it seem reasonable that they never attempted or were never successful in hacking Mrs. Clinton's personal email accounts or one of her devices?
No, it concerns me a great deal, and that's why we spent so much time to see if we could see fingerprints of that.
Well, you said in your statement regarding your recommendation not to prosecute, to be clear, this does not suggest that in similar circumstances a person who engaged in this activity would face no consequences. To the contrary, these individuals are often subject to security or administrative sanctions, but that is not what we're deciding here. Do you stand by that? After,
Yes.
Okay, I thought you would. You also said you could not prove intent. What I want to touch on a couple things here. One, a reasonable person would not have compromised classified information by keeping that information on inadequately secure private devices. In other words, such a person would be viewed as unreasonable and unsuitable for any position in our government that included any responsibility for handling and protecting classified information. Would you agree?
I would agree it would be negligent. I can't prejudge a suitability determination, but it would definitely be stared at very hard.
Well, what we're dealing with in this hearing is not the lack of due diligence in handling routine government data or information, but the lack of due diligence by Secretary Clinton and her carelessness in handling classified information that could have compromised American national security and, as Mr. Hurd pointed out, the missions and personal safety of our intelligence agents. That troubles me greatly. Based on your answers regarding Mrs. Clinton's use of email, and based on what we know, it seems to me that she is stunningly incompetent in her understanding of the basic technology of email and stunningly incompetent in handling classified information. I mean, you should never associate the Secretary of State and classified information with the word careless. It doesn't matter. I mean, we have to exercise the utmost due diligence. All of us in this committee do in handling this. You do in prosecuting cases. And I see that in what you're trying to do. I just think we need to leave here with this understanding that there's more to this story than we know. If a foreign hacker got into this, I can assure you that they know what was in those emails that were deleted. They read them all. They know what is in the emails that we never received. Mr. Chairman, I yield back.